if I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I begin, for those who may not know me, I'm a Texas trial attorney. Y'all see the law license on the wall, signed by the 9 justices of the Supreme Court. I was minding my business. I was drinking my water. Somebody said, we are expecting a verdict today. The jury instructions will be read, and after that, the jury will go deliberate. And they will come back with a verdict of either guilty, not guilty, or they could say, Judge, we are hung. We can't come to a decision. It's a hung jury. And then at that point, either the prosecutors can decide to refile the charges and bring it again, or, hang it up and say, hey, we tried. Let's jump right in. Right now, they are going over just legalese, just legal stuff, lawyer talk. So we're gonna jump in and see what they're talking about. It ain't nothing major, just nothing major at all. All right, I guess we can get some sound. That'll be good, huh?
From my understanding, we're just to, redact.
Hey, good morning.
Essentially, yes, Your Honor.
What's it
right.
like a heart attack?
And I'll let Mr. Floyd.
I mean, I think that there is evidence
Lady J.
presented for that. And I hope y'all understand what my thinking is on because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute. And that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon, you don't have to be possessing it while committing a crime. You just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to supplement what my colleague Mr. Adkins was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point that this does different work as an overt act than it would as a separate substantive charge. Frankly, only just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. And just he is in possession of a weapon.
I know y'all didn't allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't.
They cannot return. I find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element. So unless you've got case law, you're not going to convince me on that one. We have moved on to whether it should be redacted, modified to essentially assert a section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the state may be able to find a case, but I haven't, and you may be aware of a case, Your Honor, and in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back
I
and
do not
fix.
have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made or whatever, fix what they have done at this point in time by modifying the allegation of this overt act. At this point, I just don't think you can do that.
It's not
I think
legal.
the only option is to redact it, Your Honor, and I think it would be error to go ahead and change that.
I don't know. So
because that's what we have been.
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175, 189, and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that, but I don't know whether we can change it like that. So we'll come back to that.
Just so that's clear, do you want specific law subject and apart from what was provided last week that would allow?
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act. All right. So our next issue let me jot myself a note down. All right, the overt acts that include Mr. Kendrick and others that I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up the, what count is that, Ms. Persfield? Okay. I'm sorry, the count. We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Yes, Your Honor.
Okay, all right. Now, the somewhat more complicated issue is when we go back to the overt acts, because that same thing is essentially included as an overt act as well, and those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could think, well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that because they found that Mr. Kendrick.
Agreed. So here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick. And then maybe a 183A that says, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've
Was-
already determined that.
So is the, just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just
Sure.
be Arnold and Williams with the.
Codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of can we then go and modify? I guess we can modify these overt acts. I don't know
mean,
if we
it
can
seems
modify.
like That's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that, you know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, while I probably should, I'm not disagreeing with the court on what you're saying
Yeah.
with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative
All right.
of some of
And
those issues.
you say I probably should, but you shouldn't if you,
Well, I mean,
I appreciate that you take your duty of candor seriously. I really do. So thank you. Yes, sir.
Your Honor, with regard to count or Act 183,
Yeah.
if the jury unanimously finds that this overt act was in furtherance of the conspiracy,
Yeah.
I believe with the instructions the court will be giving when you have multiple parties, you know, and could mean, you know, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the
Yes, Your Honor.
challenge with that, and just kind of think through this hypothetical with me. We have got Overt Act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood.
And
Judge.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have had no.
That's true.
count, so there's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would qualify as that, but it's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between the substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly.
Okay, but that's not them, all right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who it's alleged to have done overt act 183. And I have directed, and it's only, Cody, and I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay.
And we're gonna come back and talk about it, so I don't want to.
All right.
I'd like to be.
Think it through before we know what the case law is. Okay.
Thank you.
Appreciate it. All right. The next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence, and that ought to be easy enough to check. And honestly, I think Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was what you said was 60G, 30Q, and 487VV. So can we just pull those and or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the?
I mean, the actual
You want me to pull
piece of evidence would be probably the easiest.
She put that black skirt on y'all today. Hey, good morning. Thank y'all for popping in. So Tia had asked, do I think, I mean, it just depends on how fast the judge read, because I don't think we're taking a lunch today. They're coming in at 11 o'clock. She said, come in, with a fed belly, because we're not stopping. So if she powers through from 11 and just keep reading nonstop, we might get a verdict today. I think the jury want to go home and get ready for Thanksgiving. They got to start cooking tomorrow. So, if she let them go ahead and power through the rest of today like we did last night, we might can. Yeah, we were here for over 11 hours. I don't know why YouTube not sending out the notifications. But yeah, we were here. But it was a lot of music played, so I have to go in and edit a lot of that out. I'll have my editor do it, and that's a lot. 11 hours of video. You gotta go and find like 10-second clips of music, but I think YouTube might do it. Might can crop it automatically. I'll see. And that's crazy because the songs they were playing were Young Thug songs. Like, we're not trying to make money off y'all music. We're trying to show the trial to the world. But I'm sure it's just the algorithm that recognizes the music and pulls it. Oh yeah, Hilton. Now I knew I had already said that she's gonna come with some attitude and some sass. But she took the cake. She took the cake. She showed out. She showed. And then Tia said she was crying after. I hope she didn't do that in front of the jury to try to gain sympathy. Because that's just wild. I did see her after the closing when she sat down. She was wiping her eyes, whatever she had going on. But I mean, you just literally yelled at these people all night. I mean, she was yelling, she was going off. But then you sit down and you cry. Like what? I don't know if she's trying to show that she's passionate or what. Oh, okay. She said it was after. Thank you, Tia, for that insight. I don't know why she pulled these people family into it because we don't even know what the Drinks family think. They may think something suspicious about that last car that pulled up real fast that they never identified. I'm trying to see though, this black may be working for her. So the jury should be in soon. She's gonna start reading all these jury instructions, but oh, you did get a notification. Okay. I don't know how they decided. some people get it, some people don't. I guess you got to make sure your notifications are turned on all the way. So hitting the subscribe button, that's only part of it. But you have to hit that button and again and go to all notifications, if I'm saying that right. Okay, Keys Mobile said one of the family members been doing interviews and they not feeling the prosecution team. Well, who was she hugging and crying with last night? Hold on, let me go back and read that. Oh, she said she was hugging Drink's mother. I'm sure the family just want the truth. That's what the family want, the truth. Somebody said love. Love was looking proud when Hilton was doing the closing. I mean, oh my God. Playing with these families' emotions.
We were just dealing with other issues.
And Your Honor, unless I missed it, I don't believe the Arizona conviction came into evidence.
If 438 VV, now you had cited in your closing presentation 487 VV.
It was 438 BB, which is this.
Okay.
For.
All right. So it doesn't look like the Arizona conviction came in. So all right, so we're starting with overt act number 3. Y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
That is going to. Yes.
Hmm?
One moment.
It's neither of these. Aren't there 3 for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me 2.
Like you say, they get.
I handed you the two that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence? I just assumed.
Somebody said he love hiding. She know the jury.
Cited all of them in your closing, but that's okay.
I mean, if Hilton was gonna act so hood last night, I mean, you might as well let Love do the closing.
No, this is- it can't be that one.
Love was falling asleep, but once Hilton got the cussing and carrying on,
I think it's still somewhere in one of those bins.
Love,
Is in
she
evidence.
perked up. She came back to life. And started smiling and shaking her head like, yeah, that's how you get them. Like a mama bear to her cubs. That's how you do it. Oh my God. She said, I was in bed. You couldn't do nothing but be in bed. Somebody say, Love put that battery in her back. You got to acting bad.
All right, Ms. Pressfield, the burglary one, there is a conviction for, so we do need to define burglary in our overt acts.
Not church.
2013 Act. Okay. Okay, all right, as long as there's, okay, so there's some evidence, okay. All right. Just a second, sorry. All right, and we've already defined possession of marijuana and to distribute anyway. Yes.
I don't think it's necessary to define the, I guess, the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges
Okay.
and confusion to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then that's, they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable. All right, so then 55. So are there other overt acts that have been proven by somebody else's conviction being admitted such that we wouldn't have to define those either?
Yeah, so the jury should be in soon, but it appears the state first indicted this case, then they re-indicted it to try to fix errors, but when they re-indicted it, they messed up even more. So now they're trying to fix it now. But the thing is, once a grand jury indicts you, then you are indicted on that specific charge for those specific elements. You can't come to trial, especially after the trial is over,
All right, y'all, Overt Act 58
and try to fix it.
alleges possession of a firearm by a convicted felon by Mr. Kendrick by possession of a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence? Not the Arizona conviction, but the, I guess, I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have for 38B.
Okay.
That October 1st, the conviction for that October 1st crime is 430.
Yeah, so they messed it up, and we don't know if it's messed up by accident because the state is sloppy, or they did it on purpose because we know they slick like that. They'll try to conflate some stuff. I don't worry about that. Just merge it all together. It's the same. It's the same stuff. It don't matter. No, it's not. The grand jury indicted specific charges, then you have to take that charge to trial. The judge like, hey, find me some case law, see what we can do. See if I can help fix the state sloppiness again. No, judge, no. Enough is enough. We're not doing that in this season. We passed that. We're not going to be delayed today. We know what the state's intentions are. Bruce says on purpose. So now,
You can put it back where it goes.
they brought brains in. This
And
brains.
Have y'all come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence?
Your Honor, we are looking. Your Honor, we're looking at that now, and I think the court just addressed this, but just with the Arizona conviction.
Yeah, we don't need that one. We just need that one that was satisfied.
Hey, good
Thanks.
morning. I don't know. I mean, I think Max and Doug did a good job of sending the jury the correct message about what happened with their clients. And we got to remember, Max and Doug, they don't have to prove anything. They don't have to show anything. They don't have the burden beyond a reasonable doubt. That's the state's job. So we can't even put Max and Doug on an equal playing field with how Hilton performed, even though they blew her out the water, in my opinion. It wasn't even close. Like the defense attorneys, they can say, coulda, woulda, shoulda, this happened. It was maybe the car went this way, maybe it did not. But the state, you can't do that.
53.
The state was like, maybe they went down this one-way road and they made a U-turn. It don't matter, the road is one way. They don't follow the law anyway, so it's possible that they did. They could have turned around, switched cars. It was too much of maybe this, maybe that. Maybe it was sunny, maybe it was cloudy, maybe it was windy, maybe it was rainy, maybe it was snowy. No, Hilton, we need to know for a fact before we put somebody in prison for the rest of their lives. It's too much, maybe, possibly. He could have just did this. I don't think that's enough for, a civil trial where the burden is way lower. We're talking about a criminal trial. And we saw that chart that Doug put up.
Sorry, Overt Act 34 is Walter Murphy, possession of firearm. Is that established by a conviction? Or am I going to need to define robbery?
Not pinky up a Friday. On one of the Fridays.
Okay, that may have been the only reason we were defining robbery. So we would not need to if there's a conviction.
Oh my.
So we can take that out of our jury charge.
Oh man, that is funny. Y'all
I'm
would,
glad you pointed that out, Mr. Abadi. That'll make it somewhat easier. Mhm. Oh,
yeah, I like that reference.
right, I'll have to look in a second.
I've had trials where instead of using a dollar bill, one prosecutor had a gun with missing pieces, and they basically say even though all the pieces of the puzzle doesn't show a full
It
gun,
doesn't look like there are any other overt acts, because I just did a
circumstantial evidence can show y'all that's a
search in the
gun.
indictment for the term convicted felon, and
And I,
that looks like those were all of them that didn't otherwise have some definition anyway.
and of course the judge allowed that in. Judge, they can't be trying to inflame the jury while we doing voir dire, showing a picture of a gun. And especially in a trial that alleges a gun. In the indictment. Let me see if I can find. Right, possession of firearm. Yeah, so I'm looking at the re-indictment that the state filed, and it's a mess. It's a lot of legal stuff that lawyers can, sift through, but just know it's a mess. Just like the trial, so don't be surprised. And now they're asking the judge, hey, judge, just fix it. And what Doug and Max were saying is you can't fix it. It's too late. This is crazy work. And that's how you know the grand jury, they don't know, just a group of people, citizens. And a lot of times they just rubber stamp whatever the prosecutor tells them to do. It's 10:30 and they're still scrambling. It's great. Right, the jury's gonna be there. So but yeah, Floyd, they try to bring him in to convince the judges that what he say is law. But Judge Whitaker, like, nah, show me some case law. And he loved running time. Oh, the federal court say this, the federal court say that. Well, show me some case law from the federal courts. Now, why he not on nobody's computer looking up the case law? I know the case law ain't on his notepad or whatever he writing. He probably know with some BS himself. He know he can't go back and change that wording of the indictment right now. Oh, this is the judge's first RICO case. Wow. And her first RICO case just happened to be a let's just say non-traditional RICO. She getting some good practice with this case. Hey, good morning, Paris. She's getting some good practice with this case. Instead of mess. Oh, look up. Oh, they got a. Oh, Abate looking up something. Oh, they got Abate looking up research. Oh, and in Atkins too. Somebody say it's a hybrid RICO. It's a hybrid RICO. He said, YSL, they're not a gang. No, they're a hybrid gang. What's a hybrid gang, detective? Take for example this gang in LA and this gang. No, what's a hybrid gang? What's the definition? Without using an example. A hybrid gang, whatever we say it is. Okay. There's no definition. Whatever way the wind blows that morning, that's a hybrid gang. So then we got a hybrid RICO. It don't have to be right. Whatever we think in our minds, it means that's what it means. Like what? The hell y'all doing in Georgia? But we watching you, Georgia. And this morning we got Georgia on our mind. Hey, good morning. Thank y'all for hitting the like button to circulate the video on the algorithm. So we can get back on YT's good side. Right. Well, the jury's not there, so we have a few more minutes before, well, they're probably lining up, getting there slowly but surely, but they're not coming out until a few more minutes. But yeah, so what the judge, she's given the state time to research case law because the indictment is messed up. and they want her to now fix it after the trial is over, the evidence is closed. And the judge is basically asking the state, how can I fix that? How can I fix it right now? Do I have the lawful authority to do it? See, Glanville, he wouldn't care. I got authority, and I'm just going to do it. Let the appeals court figure it out later. But this judge is trying to get it right, at least on this portion, and she's trying to say, you know, show me the money, show me the evidence, show me where I have the power to do this. So now the attorneys are looking something, you know, looking something they're trying to come up with. I'm sure they texting people at the office, hey, stop everything you're doing, get on your computers, research. We need to find case law that says this. You know, you got this guy over here, he's over here, you know, doing the same thing. I think Abate was looking. Max and Doug, they're looking too, just in case they have to play defense. And what I mean by defense, if the state finds a case, then Max and Doug can look at it and say, that case doesn't say that. That case talks about a different issue that's not on point with this issue. So she's just giving them a little time, but I don't think they're going to be able to find nothing that gives a judge lawful authority to override the charges that the grand jury presented at the end of the trial. So I'm thinking the best thing they can do now is if the state did not indict the case correctly, they left out elements of the indictment.
All right, y'all continue to research. I need to go up to my chambers and see if some changes might be saved on my computer up there if it aren't saved in a document down here. All right. Yeah.
Yeah, so if the indictment is not correct, if it's missing elements, it's not lawful, not legal, then it should be thrown out as a matter of law. Like state, this is y'all job at the beginning when you file this case, you should have made sure that everything was correct. See, people think lawyering is just, you got to be a good actor. If you can talk loud and you can yell and you can be dramatic, then that's all you need to do. No, you got to do the hard stuff behind the scenes, the actual work. And they indicted this case a lot. Hey, y'all saw that bailiff? Y'all saw the bailiff? She about to call Fonnie don't know. That's why they got what I call brains there. Fonnie don't know nothing. She's supposed to be a RICO expert. The very basic thing you should have done was make sure the indictment was correct. And that's crazy because a lot of times the indictments are pretty much boilerplate. Y'all ever have to do an assignment and y'all do it so much, all you really have to do is go in and change like the name, change the date. I mean, so I don't know how they got that wrong unless they tried to be creative and mess themselves up. But yeah, y'all saw the deputy, he was pointing the camera away. Let's go back. He's like, get that camera, point that camera on the wall. Look at him. This one right here. Wait, who was that hugging? Tia said, hell, he don't even know, right? He don't. Oh, my bad. I didn't know it was muted. They say that Yak's other attorney, the one that just hugged him, she looks like a variant of Judge Whitaker. Oh man. I said not a variant. Oh man, they funny. No, it wasn't the murder count. It was uh, it was a gun count. Possession of a firearm by a convicted felon. I mean, I don't think it'll be lawful for them to fix it because the grand jury technically are the ones who brings the felony charges. I mean, the prosecutor takes it to the grand jury, and then the grand jury gives them the go ahead, the yes or no. Without the grand jury, if the grand jury, no bills it, we call it true bill means the charge can be brought. No bill means it's kicked out. And they vote. It'd be a group of people by majority. There's no defense attorneys in the room, just the prosecutors. So, the prosecutors can tell them anything. So that's why, 99.9% of the time, the grand jury will come back with the true bill. And you got to be real skeptical if the grand jury comes back with a no bill. If they come back with a no bill, that means 9 times out of 10, the prosecutors didn't want the charge in the first place. The prosecutors wanted them to vote it down because that way they can shift the blame to the grand jury. You might see that on an officer-involved shooting case. Officer-involved shooting. Prosecutors probably don't think there's enough evidence. I don't really want to charge, my fellow officer that's, that works with me, testified on a lot of cases for me. I don't really want to indict him. So take it to the grand jury until behind closed doors, it's a secret meeting. Nobody can be in there. Tell the grand jury, we felt the officer defended himself, self-defense. We don't think y'all should indict him. And then the grand jury say, okay. And then the prosecutor will come out to the news and the media and the public and say, we did our very best. We tried to indict that officer, but the grand jury were the ones who said no. The grand jury said it wasn't enough evidence. And I'm like, okay, yeah, right. If y'all really wanted that officer indicted, you'll go in there and say, we believe that this officer did not use the proper use of force. We believe he did it intentionally. We believe he committed, a cruel act with the, intent to deprive someone of their life. We're not asking you to put them in prison. We're only asking you to give us a chance to present our evidence at a trial. And the grand jury said, okay, we're not going to put him in prison. We're going to give y'all the okay to indict him just so y'all can have a trial. And then the officer can defend himself later. So there's ways you can manipulate the grand jury. But in this case, once the grand jury gives the okay for a charge, that's the charge you have to take to court. That's the charge you have to deal with. You can't switch anything, any of the elements on the indictment, because if you start switching the elements, then it's not that charge anymore. It's something different. So now you have to go back to a grand jury and re-indict it and do it right. And it seems like they went back and re-indicted it and messed it up even worse. So, I mean, and this was in 2022. I think the first one came out in 21, and this one is in 22. And even the second indictment, you know, is a complete mess. Which is crazy because y'all knew it was messed up. I mean, this was revealed, I think, days ago when the judge granted a directed verdict. You knew it was messed up. You came to court today hoping the judge would just do what you asked her to do without any case law. Y'all should not be doing research right now. Y'all should have already had this done, unless y'all already know that it's not lawful. Y'all not going to find any case law because there's not any case law to have the judge change the indictment right now. Somebody said, what happened to the bloody red gang dress alike today? I know that was embarrassing. I mean, they can't dress alike now, right? The way they was embarrassed because they all dressed alike. Yeah, they got called out. And I mean, per se, I guess there's nothing wrong. You want to show unity. You want to show you're on the same team. But, you know, I don't think they thought it through, that a RICO trial where you're trying to prove that people are associated together based on colors, gang colors. They're a group, they're criminals, according to the state. And then y'all come dressed in unity, just like they do. Not only any color, but y'all come dressed like a part of a blood gang, a blood set. Like, what? Yeah, they out of all days, y'all come in there with bloody red. It's like y'all part of a gang. I mean, it was some bright red. And the lawyer said, you know, they're all dressed alike. Are they a gang? And Hilton said, we might be dressed alike, but we don't be committing no crimes, and we ain't out the Hilton. First of all, calm down. Because first of all, you were in the back room with a sworn witness with Woody, trying to convince him to say what you wanted him to say. So don't say y'all not a telling him, hey, if you say this, I'm gonna prosecute you for perjury. If you say that, I won't prosecute you for perjury. Like, you were giving him the okay to lie. And we already know Love had people locked up in the jail. If they don't do what y'all ask, y'all go send them to jail. Oh, well, if you get stabbed, you get killed, it ain't our fault. You get ate alive by bed bugs, it ain't our fault. And now it's been alleged that your boss The reason she took Young Thug's case was because she really wants his money, so the money can go back into her slush fund, and then she can pay her boyfriend Nathan Wade the money, and then Nathan Wade can spend the money on her. So don't say that y'all ain't no no criminal organization just because y'all went red. Y'all done some sneaky stuff. Let me see. Somebody said they should have worn slime green today. She said, what happened to the they the biggest gang in Georgia, the biggest. Yep, and then oh yeah, we can't forget about the missing watch. Your detectives, it's alleged she stole the watch. She stole a $500,000 watch. We can't forget about that. It was also alleged that the federal government sent money to Fonnie Willis' office for one thing, for the youth, and Fonnie Willis spent the money on something else. You can't do that. And then when they called her out on it, one of her employees called her out on it. She fired him. So he was saying, don't be stumping around tomorrow. Well, we don't be committing no crimes. That ain't what we. He was stop. She said, YSL Tam said she stole the watch and had plastic surgery. Y'all can't make this up. Y'all can't. Not plastic surgery. I guess she got plastic surgery because she's trying to track the quote unquote criminals that she keep arresting. Somebody said, who said it yesterday? Was it Monica? They say in Atlanta, everybody going together. Everybody going together. So that should be a shot. But I'm thinking the jury should be coming. What? 3 minutes? 2? So if the judge read all of the jury instructions nonstop, we're not going to stop for lunch. Just keep reading, speed read. Then, once that's read, the jury goes to the back. And then all we do is wait. Sit and wait. I'm sure because the jury never got a chance to talk amongst themselves about the case, so it's gonna be their first time. So I'm sure the first probably 30 minutes just gonna be, what was that? Like what in the hell did we get ourselves into? Then they got to select a jury foreperson, and that person is just basically the person that helps organize, keeps the order going. Let's take a vote. Initial vote. How many think guilty, not guilty? And then if they have any questions, the foreperson will write a note to the judge. The judge will read it and then respond back. They don't get any more power, though. They can't force someone to vote this way, vote that way, or my vote counts, twice as much as yours count. It don't work like that. Everybody get one vote. BBL, not BBL. He said, how boring is the jury instruction going to be? Laura, let me tell you right now. Let me tell you now. After something happening, breaking out, it ain't gonna be exciting. It ain't gonna be just like over the top. Oh my God, jury instruction. But this could be the last day. So we don't want to take that for granted. You know, because some people say, oh, jury instruction, you know, I'm not gonna do nothing today. It could be the last day. Then what y'all gonna do with y'all lives? So what y'all gonna do? We're gonna jump to the next trial or what? We're gonna jump to the next trial. Let me see. I wish somebody had like some best moments. They probably haven't had time yet from the closing arguments. Let me see. Because the way the way Hilton showed out, I don't think you can make that up. Good morning, Danielle. Doug probably has his investigator going to every pawn shop looking for that. Oh man, that watch gone now. That watch is gone. Let me see. Anybody have any thoughts y'all want to talk about? We got a few minutes. Yeah, might as well. Or you want to stream the other two defendants? So they're gonna have only two more by themselves? Let me see. YSL trial. All right, the jury should be there. The judge said that she ran upstairs to her computer to see if something saved. That's gonna be crazy if she can't find it. I don't know if she's gonna have to start from scratch. Maybe she forgot to hit the save button, or maybe it's on her laptop. She calling her husband at home, check the computer, you know, see if I did it at the house. Miss D said, you said she was going to come in high, but she came in flame. I mean, I don't know. Like, I don't know if it was the nighttime, the late hours, or maybe it was the music. Maybe she thought she was at the club. I don't know. But she just started just clowning. She's stomping her feet. It seemed like she's doing a little shoulder shake. Like, what is going on? Oh man, y'all. Let me see. I wonder if I can find I wonder if I can find it. Just some of the part. I mean, she started off cold, but at the end, she just got more performative. Maybe she seen some of the jury people falling asleep. Maybe she seen, so she just said, "Okay, I gotta switch this up." Love, DA Love falling asleep. But once she got the cussing and stuff, boy, I'll tell you, brought life into Love. Love sat up so quick. and start smiling and shaking her head. Yeah, that's it. Fonnie at the house with her gray goose. You know, she was watching the TV. That's how you get him. That's how you get him. Get him, She said I was laughing at Houston doing the lean back, and rock away. I don't know what. Kept us all the way there till 8 o'clock. Her and Nathan watching. Oh yeah, you know they watching together. Let me see. Hold on. Let's see. Let's see. Yeah, don't forget her young. Like, she was out of control. Like, what? Yeah, I'm trying to see if we can find a clip. If somebody got like a. They probably haven't had time yet to. Let's see. See. Hey, this is one of my parts here that was just she like because I think one of the defense attorneys said you didn't see a muzzle flash. She said somebody you ain't gotta see no muzzle flash. But Drinks he dead though. He dead though. Like what? Why did you say? Let me play that little part right quick. She said, but he dead though. Let me see if I can. Yeah, yeah. This is
Nonsense. He don't see no muzzle flash. Mr. Drink's dead though. Nonsense. There's no muzzle flash anywhere on the video. So this is nonsense. He don't see no muzzle flash. Mr. Drink's dead though.
Hilton. Oh my god. Yeah. I don't know. Uh, um, hold on. What? Let me see. Oh yeah, we're caught all the way. I'm just making sure we don't miss nothing. Let me. Let me see over here. Hold on, y'all. I found another part. She tried to say that somebody else put on. Nobody put on Hilton more than you. You put on. When I tell y'all she put on a show, she said somebody else put on and had all type of foolishness. No, Hilton, that was you. You the one. You the one that put on with all type of foolishness. Oh my God. Let me see. All right, let's play this little clip right here. We got some time. Let's see. Where is that? All right.
You know, I actually do like rap music, contrary to popular belief. And there is an artist, Young Thug, and he has a song called Put On. And I'm gonna tell you what Copeland and Zachary did while they testified here, was they put on for YSL. They came in here acting all types of foolishness. And that's because they wanted to show their gang member friends, look, I'm still part of the conspiracy, y'all. I know I snitched on y'all back in 2015, but I'm gonna try to help y'all out as best as I can. And that's
She said she like rap music. She like Young Jeezy. And they put on and did all type of foolishness. No, Hilton, that was you. You the one that put on. Okay, here we go.
Okay.
Doug, watch him. Look, he reading.
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F second 880, it's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive did require the acquittal on a RICO conspiracy. And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction. But that being said, we are looking at the changes that were just forwarded to us and think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then?
Bring out the jury.
Otherwise, I'm gonna have the jury out and go ahead and
All right,
charge them.
wasting time. Let's go.
All right, let's get the jury out.
Hey, good morning, Ken. Goddess. KK say, shake your mouth. What's going on, Jiggy? He say, now I know what Woody meant when he said Hilton was trying to talk like they went to. He said that she tried to act like she like, you know, like she from the hood and stuff like that, the way she be talking and stuff. Uh-oh, there go Love. There she go. They say the yelling and screaming part over, so now you go to the back table. We need brains up here for this part. Yeah. Look how Love, look. And supposedly Love was in charge, and then she passed the case on to him. And before it's all over with, now they both sitting in the back row looking crazy. She said, not undertakers. She went. Oh my God. Boy, congratulations to him, though. They say he a newlywed. I know he gotta be, his mind all over the place. Gotta be, he fighting for his life. He want to get out. He's been in jail. He got to make sure he's safe at the Fulton County jail. He got a new wife at the house. I'm not sure if he has any children or not. So he's thinking about his honeymoon. That email from John. Y'all are funny. Somebody said he got stepped. Y'all know what? Y'all are funny. What? They say she gotta have some faith in Max, and Max brought his A game, I will say, in that closing argument.
Violation of the Georgia Controlled Substances Act, 61, possession of a firearm during the commission of a felony, and 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants, as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick, and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell, and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor.
So she got Diet Coke and water. Come on.
You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang, that is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity.
Come on here.
For malice murder, the state must cause the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to define the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions.
Wow.
I'm going to excuse you all to the jury room now to
Wow.
elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
Here we go. Here we go. The jury has the case. So the people that's popping in, no, she just read the jury instructions. They haven't started deliberating. They haven't been out yet. They're on their way out now. 313. Good morning and good afternoon to some of y'all, depending on y'all time zone. Monica. So yeah, it's just been turned over right now.
All right, y'all are the alternates in the case.
No, he's a regular.
Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty.
Mm-hmm.
You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. while y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were, because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions. Just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great, I may see you again, to your fellow jurors, and then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
Yeah. So yeah, you definitely need the alternates separated. I've seen mistrials happen because the judge allowed alternates to go in the jury room and deliberate with the regular jurors. You can't do that. So it's a mistrial.
Are there objections to the chart?
So you have to keep them separated.
Okay. On page 2.
Turn your mic on, Hilton.
Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on a second. Let me get there. Page. Where are you talking about?
So count 50, where it's participating in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me is correct.
Okay.
Hilton by.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on. Yes.
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement, or made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We
No.
probably should have.
Too late.
Just,
I gave y'all this, I don't know how many different times to
Too
look
late.
at and ask you. I don't know how many
No.
different times for any kind of comments or corrections. So
No.
what do you want me to do?
can we add it, and then when you send it back,
Just, sure.
that's all, Your Honor. I'm just going back.
Made by one of the defendants,
No.
made
Okay.
to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you.
Free the jury.
Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of a firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know Your Honor stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
What you mean? I thought everything goes out.
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper,
Okay,
and we're just going to attach the flash drive to the piece of paper.
okay. And
Okay. What?
those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive.
That they can't play.
I'm not suggesting,
We don't normally send the actual media out with them.
okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, I'd like to watch the FedEx tape again.
okay, my understanding, I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled?
No.
Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, I believe defense counsel has an objection. We were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
Don't do that.
I don't know what you mean by that.
Don't.
So every act that we presented, so for example, VV was the Chamel drinks.
Don't do that.
So that they can know when they pick up a
Hmm.
letter,
Mm-mm.
what that was in reference to.
Matt, tell her no. No.
I'm going to object to that.
Smart man.
The state's kind of direction of
Hell no.
compartmentalizing the evidence, and quite honestly,
Right.
some of the evidence that was admitted under certain letters applies to certain other cases. I mean,
Mhm.
these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance.
That's a bad idea.
What he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that
Mhm.
it's really appropriate to say, here's
Exactly.
kind of the state schematic of
Exactly.
evidence. Okay.
Not even close to appropriate.
So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
Just let them ask for what they need.
I've been presented some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention.
Mhm.
I don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the
Okay.
demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay. All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence
Okay.
that demonstrative does go back to the jury, and it's a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your
Okay.
Honor. This state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on the point, but we are looking for that case.
Y'all doing a lot of looking at the last minute. What's going on, KB? It's been a minute. Say good. Yeah, Hilton trying some trickery. And I'm glad Max shut that down right away. No, ma'am. I've never heard of nothing like that. Where you tell the jury what evidence goes where. This evidence goes with the drinks murder. This evidence goes with the nuts murder. No, once it's in evidence, they can consider it however they want to. You can't label it. And let me see if I can explain the continuing witness rule. Some states have a rule where they don't want certain evidence to go back with the jury, because if it goes back with the jury, it may get more credibility. It may receive more credibility than a person on the stand. So when someone comes to court and testify on the stand, you only hear from that person one time, and then they're gone forever. They don't come back to court, they're gone. But if you have like a police report and they take it to the back, that's a continuing witness. They can look at that police report over and over and over again, but they can't listen to the testimony of that witness over and over and over again. So they want to make it fair. Like certain stuff should not be allowed to go back where the jury can consider it and give it more credibility than the actual witness that was actually on the stand for 30 minutes or an hour. So that's why the defense attorneys try to stop a lot of documents from going to the back, because those documents would then become a continuing witness where they can, read it 1,000 times versus listening to the credibility of one witness on the stand one time. But what Hilton just said, she said some of this stuff doesn't apply to the continuing witness rule. And she said she's trying to find the case law for that.
March 2021 case, spelled PATTAROZZI, state 385 Georgia Appeal 675. It stands for basically what the continuing witness rule applies to, and CAD report would not be something that is listed as something that wouldn't go back because it would be a continuing witness because it's the original evidence.
I don't even know what case. I couldn't hear him.
Does it cover CAD reports at all, or is it just kind of here's what continuing witness means?
It's just kind of just here's what continuing witness means. I couldn't find a case specific or on point of the relationship.
It's hard to believe, honestly.
Leads me to the conclusion they go back.
Yeah.
So he didn't give her a case that's not relevant.
So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, it contains the reduction to writing of an oral statement, doesn't it?
Yeah.
So it may be that it can go out redacted.
I mean, see, it's still a writing, and that writing can be read, like I said, over and over again. Is that fair to let a jury read something over and over again when they only heard the testimony of that witness one time? You just say redacted, but if you redact it, then what's the point of even, sending it, right? If you get a paper and everything's blacked out, I mean, what's the point of even getting the paper?
What does CAD stand for? Computer aided.
It's like dispatch notes. When the dispatch is talking to the police officers. I don't know what you mean by no videos. No videos. And they're allowed to rewatch any video they want to that's in evidence. But normally how it happens is you don't just send back 100 videos. You let them come to you. Hey, can we see the gas station video again? Can we see the drinks video when he was at the light? And then either the judge can send the video to the back, or the jury will come back out with us and then play the video while we're there. While we're all in the courtroom, bring them back out. That's how it normally will work. I can't believe that they're still arguing. Juries are ready to do.
Mm-hmm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls,
Mm-hmm.
in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony in terms of that non-testimonial analysis.
That's a different
Is
field,
part
though.
of the genesis of the continuing witness rule.
Mm-mm.
But
That's not the same.
that was why I wanted to share that.
Just sit down.
And this is coming from,
Coming from where? I'm going to look it up right now.
I believe it's the same case that Mr. Abadi cited, the PATTA. But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new, Davis v. State, 371, Georgia Appeals 469.
I mean, in the Padarazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony.
Well, if she read it like that, then she will. If she's going to take that reading,
And it is original documentary evidence.
she's going to rule with Atkins. Let me go back to it and see what I read. It's let me see, in
And
Georgia.
I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
It is true. It is what Mr. Atkins said, to my recollection is completely accurate, as we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections,
Right.
and some were redacted.
Yeah.
Well, send it back there redacted.
All right. So then I think it would be my conclusion that it is all right for them to go out as long as they are all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously.
Just send it back there like that.
All right.
It's not gonna make
y'all-
sense.
I hadn't had a chance to look at the demonstrative law yet.
Oh man, this is funny. But a lot of this stuff, we as lawyers, we may be talking about this. The jury don't care about no CAB report. The jury not gonna even look at this stuff. So we're really arguing just to argue at this point. Let me see if I can pull this up. But it's unfair. I'm gonna see if I can bring in the comment from the case. From what I pulled from the case that he just talked about. Let me see if I can pin this comment. I don't know, it might be too big. So here we go. In Georgia, the continuing witness objection is based on the notion that written testimony is heard by the jury when read from the witness stand, just as oral testimony is heard when given from the witness stand. But it is unfair and places an undue emphasis on written testimony for the right to go out with the jury to be read again during deliberation while oral testimony is received. But once, okay, the type of documents that have been held subject to the rule includes affidavit, depositions, written confession, statements, and dying declaration. So dying declarations is somebody, tell the ambulance worker, they've been shot in the ambulance, the medical people show up and they're getting ready to zap them and they bring them back. Who shot you? And they say, hey, Mike shot me. And then they die. That's a dying declaration. But in that list, we have affidavits, depositions, but we don't have CAB reports. And then what they're saying is CAB reports are not included. So what the judge says, since CAB reports is not included, it should come in because it's not really testimony from a witness stand. It's non-testimonial. Let me delete these comments that's taking up half the chat. I just copied and pasted from the law that he quoted. All right, took mine out the way.
All right. My rating of reference is that demonstratives can go out with the jury. If y'all got something contrary to that.
Can we just be clear what demonstratives we're talking about?
So yeah.
I believe there's some physical evidence that Ms. Weaver may have in her
She's got guns and drugs.
drugs.
Neither of those is going out to the jury.
Oh,
If you have pictures of them, those can go out.
not guns and drugs. Hilton, I mean, they don't need to see the guns. They don't need to see the drugs, Hilton. I mean, they have pictures of all this stuff. You don't need the actual gun in the back for them to take a look at it. I mean, that's about as ridiculous as it gets. They know what a gun look like.
Or you suggest, is there anything besides guns and drugs that she has?
That's what we're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. and, I
Okay.
mean, some of that may or may not.
Not
What-
sure we want that to go out with the jury either,
Right.
considering the allegations in this case by one of the attorneys.
Ooh.
Plus, we've got an armed guard in there.
We're gonna go over the exhibit list, trying to see what else this Reaper may have.
Y'all got pictures of the jewelry,
That's
and
what I
pictures of the
said.
guns and the drugs, right?
That's what
Okay.
I said.
And those are those in evidence?
Some of the picture of the jewelry.
Okay.
Oh my goodness. Bro, they really delaying this for no reason. This is
Mhm. Sure, absolutely. Yep.
and then they were like, okay, if it's not the guns, it's not the drugs, what else do you want? She said, oh, the jury. And the judge was like, you sure you want the jury to go back there, especially when Viverito is alleged to already stole a watch? And the judge said, unless y'all have an armed guard in the room.
There
Judge,
seems to be pretty.
the armed guard was the one that stole the first watch. The armed guard, what you talking about?
Excuse me, Your Honor.
Yes.
Oh,
Regarding Ruffin v. State, having looked at the demonstratives the state plant would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses. Whereas
Okay.
in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
so how does that go back? If it's a
So I'm looking at, it's a fairly old case.
case, let me see.
From the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on.
I can't hear you, Paige.
Let me find that part.
Please find.
Oh, Gabbard v. State,
Yeah.
Your Honor,
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
Let me go back.
These were also anatomical drawings to illustrate victims' testimony.
Thank you, Stephanie. Don't have me laughing all day. I could.
Sorry, was that Moore v. State? Thank you. Thank you, Mr. Abate.
All right, we go to Morvey State. Demont. Demonstra. Wait a minute. This would be a different case.
This case, Your Honor,
Mm-hmm.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKenzie versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of, there it was the DeKalb County DA's office, based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CATA reports as described, redacted, and demonstratives going out. Other.
So there are some piece of physical evidence, Your Honor, hats.
Okay.
Other clothing items that
Yeah.
we're having someone go to retrieve to bring them down.
We
Okay.
don't need
And I
that.
think by the time we retrieve that, gather everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter. There are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm
In January.
yeah.
I don't-
Those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, that might be a good idea.
Come on,
I
Judge.
feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
I'm telling y'all, the jury don't need none of this, y'all.
Okay. Well, good.
Oh no, no, you good, Stephanie. No,
So,
thank you.
I keep.
That's really kind of you. Thank you.
Can you do that?
I'm not. We all good.
Yes.
I didn't see you yesterday, Stephanie. I don't know if you got the notification or not. I know you know how it be. Sometimes they send it, sometimes they don't.
During testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it demonstrative.
Oh, you was in the bushes.
Encourage the jurors to write is kind of the way I saw it.
You must have been hiding.
The message right is down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm gonna put these right here with the, not those.
Okay.
Stephanie, maybe I'm.
All right, let's take, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess, and then maybe we'll come back and once it's settled, okay?
That was for the cameraman. She. Oh my goodness, y'all. So the previous day, Stephanie, maybe I'm tripping. I don't know. Yesterday the stream was over at 11 hours. So maybe I'm mixing up the parts of the day. My bad, Stephanie. Stephanie said she was here in the light. But yeah, maybe. Oh yeah, you did. You did because when you popped in, I think you came in and you said Texas, Texas, Texas. Yeah, you did. You did come on. My bad. My bad. You're right. You're right. You're right. Yeah, it was a long day. When I tell y'all, as soon as I got out the shot, I had to snatch this thing. I'm like, I have to go find some food. I said, man, Hilton kept us all day. Yeah, so the jury wait, and she told the jury, come already eat your lunch before you come. Since y'all come in at 11, there's no need for us to take a lunch break. But now she has the jury there. They already have everything they need, the instructions, but she's not letting them start because now she's saying come back at 1:30. Oh man. I guess she didn't want it to be look embarrassing for the court. The lawyers are running around looking at exhibits, holding it up. What about this? What about that? Like they're unwrapping Christmas gifts at Christmas under the tree, just pulling this, rip that paper off. Oh no, we don't need to throw that to the side, grab another one. Like what? So she was trying to say recessed in place, aka put the camera on the seal. Right. They say, what else should we have expected? Yeah, they're always unorganized. Always. But I'm telling y'all, this stuff, the jury is not going to ask for a video that they've seen 10 times, 20 times. Hilton even played a lot of those videos in the closing arguments. Nobody want to watch that again. I've been in some good trials. I mean, some good trials with some good stuff on video. I played it over and over. The state played it over and over. The jury don't say, "Hey, can you give us that tape that we already saw 20 times? Can you play that again? Can you bring it to the back? Or can we look at a cab report?" The only thing they're going to be focusing on is the guilt or innocence. Did these boys really do what they said they did? Not who called 911, what the dispatcher said to the officer, what the officer responded back to on his radio, or whatever. Hilton say, let's go. They're trying to find some clothes to send to the back with the jury. Why do you need to send some clothes? Are you trying to get an emotional response? So these are the clothes that Donovan Thomas wore the last night before he was gunned down and they're covered in blood. The jury don't want none of that, in the back, respectfully. A DWI case, the police officer draw blood. The jury don't need the actual blood itself to be in a jury room. Like what? Oh yeah, thank you. Shout out to Kokomo. Maybe once his job is done, maybe he'll be able to come on and give us some background. See, because I thought Kokomo worked for Steele, so I thought, when Steele and Young Thug and Keith Adams, when their case was over, Kokomo was done, but apparently he works for Max. And since he worked for Max, he was helping everybody out, the whole team. So hopefully he had this collection plate going around. Like, hold on, I'm doing all this work for all of y'all. Hopefully they took real good care of Kokomo, but you never know. He may decide to come on the YouTube streets after this trial is over with. Love gets her head's gonna drown. The state should put their Undertaker blood on to dig a nice hole for this case. Y'all, since we have time, what y'all want to do? Do y'all want to just stay here, wait? Do y'all want to watch some of the closing again? Do y'all want me to drop the link? Do y'all have some comments, questions, concerns? Oh yeah, we good. Or do y'all want to just reconvene and we can all come back at 1:30? Oh yeah, they say we done with Hilton. Don't you play that tape, boy. Don't you do it. We done with her. Leave it where it's at. Yes, it was just no, actually. So the case officially is given to the jury, but the judge told them don't start yet. We want to give y'all some more stuff to take to the back with y'all. Like apparently Hilton want the gun, the drugs, and the jury to go back there. And y'all saw the judge so shady. Did y'all see the judge? She is so shady. She said, "You sure you want to send the jury back there when your lead detective was already accused of stealing a watch?" She said, "Not only that, the only way we can have it back there is if we have an armed guard watching it." And I'm like, hold on, the armed guard was a detective when the watch first went missing at Young Thug's house. So armed guard ain't the answer. Yeah, I think so. Maybe they stalling. So I'm thinking they trying to just get, hey, let's get some clothes, let's get some evidence, let's push it to the back with the jury. And we're like, okay, do they really need that? Do they really need to see the jury in person or the gun in person, the drugs? I mean, show them pictures. Somebody said, can you replay that part? Yeah, let's see. Let me see if I can find that part. How long ago y'all think it was? Maybe fit?
Items of demonstrative evidence. It's Gabbard versus state.
Everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter. There are two demonstrative.
No, it was before this.
Submitted by Mr. Steele.
Let's see. Yeah, I gotta find it. Hold on. Maybe I can do it like they need to. Can you replay that part? Let me see. I'm gonna do it like this. I haven't said jury so much I forgot how to spell jury. Hey, jury, the jury, all of that, all of it. Just make it all one. Just cram it all together. Yeah, they need to let the jury, the jury, deliberate. Jury. Oh my God. I didn't even know. I said, man, after that long shift, I said, man, I don't even know. Can we backdoor again today? Did we have the energy? Let me see. Let me find this right quick for you. I'm trying to do like the judge do instead of doing it in the open. I'm trying to do it. And just say, don't have everybody seeing it. I was trying to find the timestamp. I'm gonna put this one back so we can keep an eye on that. And then I do another one to see if we can find a timestamp with Hilton. All right, yeah, I found do this one.
Or you suggest, is there anything besides guns and drugs that she has?
We're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. and,
Okay.
I mean, some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're gonna go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay.
Y'all see how shady the judge is? She made sure she announced that law, considering one of the allegations, and she lied. She lied because she might think it's some truth to it. You see that? Oh,
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking.
right.
Is there anything besides guns and drugs that she has?
We're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. and,
Okay.
I mean, some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations.
Y'all saw how long she got, considering the allegation. Oh my God. Yeah, she probably like, yeah, that woman, she went home to her husband. Whitaker went home to her husband. They talked about been reading like a dog. They tell you her, she got that damn watch. She got it. And she went and got her body done and her teeth done with it.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're gonna go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of.
Hey, and look at Love. Love acting like she on the phone, but look at Love eyes. Love looking right at the judge. Yeah, she talking about y'all. Look at her.
Trying to see what else Ms. Weaver may have.
Y'all got pictures
Yeah,
of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. And those are those in evidence?
Some of the picture of the jewelry.
Okay.
Yo, this is crazy. Somebody said she got some bad work done. Is it somebody got a picture on social media? Yesterday I was at the movie watching Wicked and it was on my phone listening to the trial. Come on here, Paris. Oh, that's funny. Right, that's how it be sometimes, though, Paris. I actually, have to go to court from time to time. That's why I can't always be on stream. And it don't be nothing going on in the courthouse of importance. I'm over here trying to figure out what's going on with the YSL trial. Like, what am I missing? I mean, what's going on? Judge, I need to step out. I know I'm I know I'm a lawyer. That do YouTube on the side, but now I'm a YouTuber that practice law on the side. I need to give me a shirt that say lawyer turned YouTuber. Judge, I can't go to court today. I gotta stream. I can't go to court today. I gotta. Can you move my? Can you move? Shout out to dear old Christian. Grace and peace to you, dear old Christian. Thank you so much. Keep up the great work. I like that salutation, grace and peace. I believe it was often used by Paul and Peter. Grace and peace. Even though I remember the story when Paul had to confront Peter, he had to rebuke him in the open. I don't know if it was too much grace and peace going on when Paul had to rebuke him in the open. Like D.A. Love got rebuked by Judge Whitaker. Rebuked her right in the open in front of everybody. Yeah, so sometimes it's a rebuking is needed. And I actually think the law actually says for the judge to rebuke the prosecutor. They actually use that word rebuke. Let me see if I can find it real quick. Georgia, when Love got rebuked, I was like, why? Because some states don't use it. I'm like, why did she say, DA Love, I rebuke you? Because that just sounded so strange to me until I actually read the law, and that's actually the words that he said. Let me see if I can, y'all can see it. On objection made, the court shall also rebuke the counsel that made the improper statement in front of the jury, and then tell the jury to do the impossible, remove the improper impression from their minds. Okay, yeah, delete it out your minds. But you say the court shall rebuke. So I found that interesting. I don't know how I got there from yeah, dear old Chris, she did rebuke her. Oh, right. And then she got upset. I believe she wanted Shard, and then she wanted Keith Adams to be rebuked as well. Because I remember Keith Adams said that she got in trouble, she got rebuked, and she wanted their team to be rebuked as well. Because she didn't want to be the only one. Yeah, I don't even know how we got here. Somebody says it felt like Sunday. Since we got a little time, from my understanding, and dear old Christian may, have this can explain this better than me. But I believe that Paul was upset with Peter because Peter was hanging around a certain group of people. But when another group of people came to town, then all of a sudden, Peter quit hanging around them. He didn't want to be seen with them because he was afraid of what the new group of people was going to say when they seen them. So he quit hanging around them. And Paul was basically saying, and not only did he quit hanging around them, he's telling everybody else, don't hang around them as well. But when the new group of people leave town, then you go back to hanging with them. And Paul was like, hold on, Peter, he basically told Paul Peter, you a Jew, but you act like a Gentile. But when the other Jews show up, now all of a sudden, you back acting like a Jew. And then you tell other people, hey, don't act like no Gentiles, only act like us Jews. But when the other Jews leave town, then you go back over there and you go back with your friends, the Gentile. He's like, hey, don't be no hypocrite. If you're gonna hang with them no matter who's in town. So he rebuked them out in the open and called them out. He said that, don't be a hypocrite. That's essentially what that was. So he just kind of rebuked them, and that's what, it happens. And not only that, I don't even think it was against I don't even think it was against any rules or customs for Jews and Gentiles to even associate. So he like, why are you doing all this hiding for? And then telling people to don't do what I do, just do what I say. Like, hey, you doing it, why can't we do it? So I think that's what the issue was. But in any event, we kind of since we got a little time, we got about 20 minutes. Might as well just talk that. Thank you so much, dear old Christian. Keep up the solid work, sir. Proud to see your growth. That's really kind of you. Thank you so much for that. Do you still stream as often? I heard on another stream a while back that you may be working a new job or something like that. So congratulations on that, if that's the case. He said your Sunday school teacher will be proud of you. TalkThatLaw. Great summary. Oh, okay, come on here. So if I get the okay from Dear World Christian, I feel pretty good. I feel pretty good. Let me see. So we got, what time did the judge say? I was gonna put a little a thing at the bottom for the people that pop in. What's going on? Why are we waiting? Why are we sitting here? But that's well, it ain't that much longer. I don't have to make a banner, I guess. But yeah. But in the end, since I started the story, and we all know that, what happened with Peter later on. He told Christ, I'm not going to deny you. And he ended up doing it. But in the end, God, obviously Christ forgave him. So it was made all good in the end. He told Peter, don't even worry about that. Just feed my sheep. Don't even worry about that. I got you. You good. So we kind of just went there. You said talk that Bible. That's how the Bible says to go. Don't talk behind their back. Do it to their face and witness. Hey, y'all saw how Whitaker just did. She didn't whisper it. She just talked out loud. She said there were allegations that you're all detectives and stole that man watch. No, I'm not talking behind your back. Everybody know it. Yeah, you stole the watch. At least it's an allegation. And then they said you got your surgery done with it, but don't give me the line. That's alleged. Oh, thank you so much, Pete. Salute, you're an attorney, but not my attorney. Hey, sometimes you got to get that disclaimer out there so don't be no confusion, right? You don't want no confusion to mix up with the YouTube universe and the actual practice of law. So you got to, I mean, you want to make sure it's understood so nobody's confused. Oh, I thought he was my lawyer. I watch him every day. I didn't think I need to sign a client agreement or reach out or live in Texas. So I let the statute of limitations to my car accident case expire because I thought he was my attorney because he spoke about a car wreck one day. Even though that may sound ridiculous, you just never know. He said, I got a black job and I need to pay for college next year. Not a black job. Not a. Shout out to dear old Christian. Thank you for popping in. Hey, this chat, we were just talking and we kind of like took off from your, I don't know, I guess I read the word grace and peace, the salutation that you always, greet people with, and we kind of just went from there. Yeah, thank you, Pete. Look at you getting blessed after spreading the word. Come on here, Miss D. Come on. Come on. Yes, I'm gonna have. Hey. Oh no. Somebody said that sounds like someone telling Hilton, "Don't act like you ghetto now." Right? I mean, that would be crazy, right? If Hilton, if she do hang with quote unquote, we just use the term ghetto, and then when she in the office, she don't want to be seen around those ghetto people. Oh, I'm a DA. I'm an attorney. I'm a lawyer. I can't be seen with nobody ghetto. And then tell everybody else, hey, don't y'all hang with no ghetto people. Only hang over here with us, the professional people. But then when the professional people are not looking, they're not there, then you go back to that part of town or those friends and try to hang with them. I'll be like, nah. Remember, we too ghetto for you over here. Remember, so stay over there. Go back over there with your friends. Go drink your Grey Goose and your vodka. Go do that. Perry said he's telling you who he voted for. Yeah, but I don't think it's no secret. I think Dear World Christian make his affiliations known. He make it known. I don't know. I don't know if you ever watched some of his streams. It's no secret. He out in the open. Right? Hey, that's what we gonna do. We ain't saying nothing behind nobody back. We're gonna say it out in the open. What we gonna say out in the open? And you see what Chelsea just said. Chelsea said that's one thing you can respect Kayla for. She didn't switch up. She always act. Hey, you can respect somebody for being themselves. You can respect somebody for being themselves. I'll tell you that. And one thing I will say, I mean, she's always been down to earth. I remember when she first came here, we spoke. I mean, there ain't no switching up. So, and I believe that she can be a YouTuber that's separate from her law practice. But sometimes we got to take the good, the bad, and the ugly. Because if I say something on his YouTube channel, somebody don't like it, and they were considering hiring my firm as their attorney, and they're like, nah, I don't like that because, you know, he was talking about the Bible one day, so I'm not gonna hire him. You know, they may not be Christian. That's fine. I'm not the only lawyer in Texas. That is fine. So long as people know, you know, being a lawyer on YouTube or any other occupation, when you're in social media or you say something to the public, people may not like it and you may lose business because of it. That's okay. At least it's okay for me. But they say all money ain't good money. They could pay you all the money in the world and be the biggest headache that ever walked through your door. Oh, you say you don't watch him because I like his commentary. You said you don't watch him just because y'all don't vote the same way. Come on. Paris. Oh, somebody said me too. Somebody said she was not ghetto yesterday, she was ratchet. DWC, why they put on what? I don't know if he may not still be here. I don't know if he left out. He probably recognized y'all names too. Oh, they say DWC, you still here? Oh, they say it's a deal breaker. Who you vote for is a deal breaker. I can kind of see that if somebody's covering the YSL trial, right? Does it really matter which way they vote as far as if they're covering the YSL trial? Now, I guess it'll make sense if it was like a political channel, right? Because you don't want to be, most people don't like to watch political news or stuff that they don't support, which, Oh, here y'all go. Oh, let me leave that. Let me leave that alone. Let me leave that alone. I don't know who Pete, what did you say? Mandy got her vote. Prayers much needed. Okay. I don't know what that means. Oh, that may be inside. Pete say, bro, I told you to display your CA. You know what? I might and thank you so much, Pete, for all your support. I might do like a different type of banner, maybe a color that's not as that takes away from the screen itself. Because I just don't want it to be a distraction when court's going on. But maybe like a black color or something that won't be a distraction. He said, "Bro, I told you to display." Thank you so much, P. You always supporting. Okay, let me see what else somebody said. He said, "You doing it now?" Yeah, from time to time. And then I also like to thank my subscribers. So I have another one said, say thank my subscribers, the new people that come on, because I don't like stopping when the audio is playing. And a lot of times y'all may ask questions, but we're watching the audio and I don't want to talk over the audio feed. So I just wait until we get a break. So what's happening in 9 minutes is that the jury will receive the case, I guess, officially, and anything that's supposed to go back with them will be given to them, even though I doubt they will want it. So the judge told them to not deliberate yet, which is crazy. She said, "I'm all for it." You said, "Make it plain." That's what make. Write it down and make it plain. That he may run who readeth it. Y'all so funny. But thanks again, Pete. That's really kind of you in for Dear World Christian. I remember when I first came on the scene, Dear World Christian received me with open arms. Y'all may not know, all YouTubers are not just, receptive or willing to accept the new kid on the block. They may think, oh, there's another YouTuber, they're gonna take food out of my mouth, or I wanted to be the only ones, or you too much like this person, or you're not enough like that person. Like, we're all different, and everybody got their own style. I'm sure there's enough people and viewers and clicks and likes and all of that for everybody. What else? What else I got? Chelsea, say for the Bible lovers, Paul in Romans chapter 7, 15 through 20 is my favorite when he gets into the struggle with sinning but wanting to do good. It's so relatable. Yeah. I'm catching up with some of these comments. Yeah. And I don't think he sometimes you rebuke somebody, don't mean you're doing it out of anger or spite. Sometimes you gotta do it with love to let them know that, hey, this is not okay. Like the judge, she rebuked Love, but she didn't kick her off the case. She let her stay on the case. And so I believe him and Paul and Peter, they remain good. Peter didn't play. Well, Peter cut off somebody's ear. What's that girl named Taisha? Shannon Stillwell ex-girlfriend. She said, "No, I didn't shoot at her. I shot her." Peter was down for the cause. He was down for the cause, but you just got to be careful because a lot of people, they say you live by the sword, you die by it. So a lot of people in the streets that's the gang banging and doing a lot of street activities, it can catch up with you. You can end up being in prison or dead somewhere. So yeah. Somebody said I'm from the Peter blood. Oh, that's funny. She said I'm from the Peter bloodline. Apparently Taisha is too. She wasn't playing. Taisha, what a. I mean, I don't blame her though, because the girls, Taisha was minding her own business. Them girls came out of nowhere and ran up on her. She said, I'm from the Peter bloodline. Oh my God. Oh my God. That's funny. So we already know, do not miss. Do not miss. Hey, when somebody comes up to you and say, I'm from the Peter bloodline, you already know what type of time they on. They don't play. This ain't just for show. He was just say she wants the evidence to go in the back room. That video was wild. I was shocked when I learned it was connected to this case. Yeah, that video, right. Yeah. I mean, but what this case is, so much to happen in this case. Like, I don't even think a movie will be able to cover it all. I mean, I don't think a movie will be able to cover this case. You just had so much to happen since Woody, testified. Woody out here, he's known. Everybody know him. He making a lot of money. Ain't that crazy how stuff flip around? When the trial first started, nobody knew who Woody was. Nobody really knew him from that area. He only became famous through the case. And I'm sure, and he's even testified he wasn't making, that type of money. But his lawyer, Melnick, was making money. But guess what? Now Melnick, his lawyer, is suspended, not making any money, and now Woody making all the money. What? I think the lawyer was suspended for 6 months or something like that. That was the lawyer that Kayla stood in for. When the lawyer went out of town, when his client was testifying, which, I always was against that. And that's the same thing that happened with this other Ashley Merchant. Ashley Merchant she had to go out of town, and they tried to tell her, well, just get somebody else to do it. And Ashley Merchant was like, no, my client hired me. I need to be there. So y'all need to find a date when I can be there or he's not going to testify. And I think they were trying to do that on purpose because they wanted no parts of Ashley Merchant. And when they saw that they weren't going to bully Ashley Merchant, you know what they did? They said, to hell with it. They said, we don't even need your client anymore. We don't even need your client to testify anymore. Heavy on the law class. They definitely need movie or book. The jury ready to, like I'm telling people, the jury may come out today. I mean, the judge is literally finna send them to the back right now. So if they go to the back right now and they work until 6 o'clock, 7 o'clock, 8 o'clock, hey, they can say, hey, judge, we got a verdict. Someone said do a poll. Okay, do a poll. So how would the poll go? That is why I like your platform. Thank you, Ms. D. I want to surround myself people who think different than me because it keeps you open-minded and not set in your way. That's true. Yeah, I always like hearing different viewpoints from different people. That's why a lot of times after a trial, I may speak to a jury to see, what everybody was thinking, their different viewpoints. Hey, spitterize for the show. Come on here, Paris. Let's say somebody say, Pete, what type of poll, Pete? And thank you for being a member, Pete, as well. Let's see what you think, guilty or not guilty, or hung jury or guilty on some, but not all. Well, see, Pete, we did a poll on Monday yesterday, and it was 75% not guilty. And I believe maybe 22% guilt, hung jury. And I think we had 3% guilty. Come on, she said t-shirts, Peter Bloodline. Hey, and from my understanding from her testimony in court, she basically said that she still, even to this day, every 3 months, she has her car wrapped a different color. Think of it as being painted a different color so that people don't know who she is. So maybe it was good for her to kind of, let people know, Shannon, his ex, or we don't even know if that's his ex. Because they asked her, is that your ex? And she like, or y'all still together? She said, I don't know. Yeah, so she let everybody know at the same time, like, hey, quit playing with me. Because I will defend myself if I have to. Oh my God. He said, oh, you did? I missed it. Yeah, it was. But we have to go through and edit it because there was a lot of music played throughout the stream. And this happened before. It's not like a YouTube, they're not gonna give like a strike. What they'll do is they'll say, take it out. In some instances, take it out. Some instances, keep it. But any revenue that's generated from like ads and stuff, it will have to be shared with the music, owner, all type of stuff. And most YouTubers won't agree to that. Like, if it's a 10-second video shown in a trial, and you're sharing your revenue with a music industry and YouTube and the YouTuber. And I'm talking about, this is like obviously for big channels, right? The bigger channels. So I'm sure the bigger channels probably won't even, if there's music play, they may stop the music or don't play the music, or pause it until the music is over with. Because obviously the bigger channels are bringing in, big money. It's surprising we never really got a movie with the OJ trial, just documentaries and then dollars from PFX. Old lady YD, how can Kayla be Woody's lawyer and Woody was testifying for the prosecution and she is married to a defendant? Well, at the time they were not married when that happened. So I don't think, they will intertwine with each other. Somebody said, okay, Judge Glanville. Judge Glanville was fearing Ashley Merchant when still had her as a lawyer. Yeah, Judge Glanville wanted no parts of Ashley Merchant at all. At all. Ashley said, I got 25 lawyers outside. And the judge like, I don't have room for them. Actually, like, they can go sit in the jury box. Ain't nobody sitting over there. No, I don't want nobody in my jury box. No, you don't want them in the courtroom. You don't want them in the courtroom when Ashley Merchant take you to school. And he was like, well, I held him in criminal contempt and in criminal contempt. And once he fixes it, then he don't have to be held in criminal. She said, that's not criminal contempt, buddy. That's civil contempt. Oh, that's funny. That was funny. Judge Glanville been holding people in contempt for years and actually had to tell him the different types of contempt. That was wild. Yeah, and like Hilton last night, she was just really just going off, and she was like, "Yeah, they telling on themselves. They telling on themselves. They dry snitching. That's a snitch. That's a dry snitch. That's not dry snitching. Dry snitching is when you telling on somebody without telling on them. Not not telling on yourself, not self snitching. Like you know, dry snitching is almost like dry begging. Somebody want to borrow money from you, they may not come directly and say, "Hey, can I borrow some money?" They may do it indirectly, called dry begging. Well, you know, my light bill is due.
Y'all can just put a joint exhibit sticker on here or write joint exhibit
My-
1 on here.
My car note
That'll work
coming
for
up.
that.
I don't know how I'm gonna make
We've
it
got
through.
copies of the redacted indictment to go out. We do not. We still have to sort out
And then they want you to say,
Those-
"Hey, I got you. I got
the
you."
language of those last couple of overt acts that we highlighted earlier. So can we figure that out?
This is so sloppy.
And do we otherwise have all of the evidence that's going to go out?
Your Honor, there was, a challenge during the lunch break to get into Judge Glanville's chambers.
Uh-huh. The deputies can get into anybody's chambers.
They just got in maybe about 5 or 7 minutes ago.
Okay.
So they're getting the evidence, they asked for a chain of custody form, and so they're trying to get a chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that.
Wow.
Thank you, Ms. Taylor.
She talking about the court reporter. Court reporter like, "Oh, you talking about me? You want me to go do that?" So apparently, multiple court reporters have been covering this trial. I mean, we've seen them. We've seen the lady here. There was another lady. I think she was a little bit older that was here. I think her phone kept ringing in court. She's older than this court reporter. And then also, you know, we had Miss Weaver. So that's 3 different court reporters. So I'm sure, and sometimes Miss Weaver still be popping in this trial. So now, and whoever it is, Miss Weaver or the other court reporter is not here today. So now they need to get a deputy to go into that courtroom, unlock that, and then the court reporter of today can go in there and grab some notes to bring them back to her courtroom. But you know how that is. I mean, is there in a specific spot? Are they going to be here, there? Do we need to wait for the court reporter to get to court to unlock it, or is she gonna give her password to the? I don't know. This is it's unorganized. But the real question is, 7 Streams say, why is the state stalling? Why they stalling? I would have typed blah, blah, blah. They would have fired me. I remember one trial that I was on, the court reporter did, they had to let her go. They had to let her go. Mm-mm-mm. And apparently she was just behind. She couldn't keep up with the court. I remember one day on our trial, she didn't show up at all. She just didn't come. And we couldn't get nothing done. So they were trying to find another court reporter to come in, but by the time they found another court reporter, the day we lost the day. So I think somebody said I think she had a cocaine problem. I don't know. I don't know. She was always nice to us. So, but yeah, I'm sure they got the hardest job in the courtroom. They got to pay attention and catch every word. You know, the judge can nod off, the lawyers nod off, not really pay attention, zone out. So yeah, it is a hard job. And I had one one court reporter. She was like, she been doing it so long, she can actually type and listen and type, and she can still be thinking about, her grocery list. She said, "Oh, no, I got my grocery list together." I'm like, how? How can you do that while Chelsea, I think Hilton just trying to persuade. So you think that you think the state is basically saying, we know we lost, we just need one as to hang the jury for an excuse to the public. Hey, we tried our best, but the jury came back hung. We gave it our best shot. But a flat out whooping, getting a not guilty, and y'all spent all this money, that may have some repercussions. Some people are gonna be upset. Have you seen this before? Have I seen what before? What are you asking me specifically? I think you had asked something like this earlier, but I didn't know what you were referring to. Have you seen this before? Oh, you're asking me, have I seen anything like this before? Is that like, have I ever seen anything like this type of scenario or situation as far as the trial? Is that if that's what you're asking me, then no. It's normally much more organized, but to be fair, I never had a trial that lasted a year. So, but normally you keep stuff organized as you go, so you don't have to worry about it. What they say, stay ready from getting ready, or stay ready, you don't have to get ready. So organize it as you go along, and you don't have to at the last minute try to organize everything. The case would have been hard. It has some days of just repeating nothing but. Yeah, I think the state did a bad job. A lot of this stuff could have been trimmed out. The fat could have been cut. But because some of the stuff offered no value at all. Then redoing evidence and going backwards after. No, oh, absolutely not. I got you. No. No. This is beyond me. Now they're trying to figure out what the law says the jury can even have in the back. Because in their state they have the continuing witness rule. But now they're trying to figure out, what does that mean? What does that apply to? And they're trying to say certain things shouldn't count as a continuing witness, shouldn't fall under that rule. So if someone has a report and they that report is based on if an expert wrote down notes and that notes is from his testimony, then that seems as if that falls under the rule. Because oh no, the report, it don't count. That's just the report. It goes to the back. Like, okay, well, they really goes against the spirit of the rule, because if not, what's the purpose of the rule? That means anybody that testify can just write something down and then it gets to go to the back. And then that violates the continuing witness rule. So yeah, it's all over the place. It's crazy. Of course. Of course. You ever had a judge manage? Yes.
Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom, and Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so. Can somebody, I guess I could do that, look in Odyssey and find out the date that's on the original re-indictment to put on this one?
And why Glenville been hanging on to the evidence all this time?
You know, when they signed, or who's got possession of the signed indictment? So that might still be.
I see August.
Is it in here, or is it still with?
I
Is
see
it making its way down?
August 5th, 2022.
We need the date, so we need to see the.
Well, that's the one I'm seeing, August 5th, 2022. It might be a different one.
I would think the case manager would have it. Right.
Unless they have a different one from August 2022, maybe one after that. That's the last one I see.
All right, have y'all looked at the highlighted language for the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor, and the state had a proposal to, I think, simplify
Okay,
the matter in terms of starting with 183.
okay,
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
okay. So leave all three of them and have those two kind of offenses only.
Yes, Your Honor.
Okay,
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
okay.
Can I ask a question? So would that mean that we would end up with what?
What is essentially 187A
183A?
and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my
But those
understanding is
wouldn't
correct.
say A anymore. They would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges and the language, The state, if you stop, like, for example, take 189 or 190,
Okay,
if you stop after an associate did commit the felony offense of possession of firearm by convicted felon,
mm-hmm,
and then redline everything up to where you start by possessing a Glock,
mm-hmm,
and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony and the date, and keep an overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court, because we do have a,
give me just a sec.
yes, Your Honor.
Somebody said, why did Hilton cry? I don't know. I know when she sat down, she was wiping her eyes. I was like, she's trying to gain sympathy from the jury. Like, I am so passionate. I wouldn't be bringing this case if it wasn't true. Find these boys guilty. And Yolanda said, no, she's trying to save a job. Thank you, Yolanda, for continuing to be a member. Thank you so much for that. Hilton cried because her job was on the line. Who gonna fire her? Let some people tell her boss just as ain't no better. So she might be just fine. She in good company. She in good company. Now if she get demoted, that may be something different. Because we got to remember, there's a whole lot of more people, a whole lot of YSL defendants still left after these two. So they may tell Hilton, like, no, ma'am, you can't prosecute them because you couldn't even handle these two. So they may bring in some new prosecutors for the remaining defendants that's after this trial is over with. Come on here, Leslie Hunter. I let me see he's a good man and a man of truth. Yeah, that's what I said, Leslie. When I came to YouTube, he was one of the bigger channels that accepted me, brought me on his channel multiple times, and also came here to over here. So I stand in concurrence, but some people in the chat they don't like political affiliate. He's political affiliation.
Was only to remove language, not to add anything.
Mm-hmm.
Nothing's been added.
Right.
I want to be clear, it is not exactly the same situation, but the most analogous thing I could find in the time available is an 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
Okay.
In that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration from the indictment that the jury saw.
Right.
That was held not to be a problem.
Okay.
And so here we're removing actually less. We're actually removing a subset of that as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial. They would have no ground to complain.
Right.
They're not parties.
All right.
So I think it's on all threes at least, but I can't really find a problem with it because we've restricted in this circumstance solely to deletion, not
Okay.
omission.
I don't see
It would
that.
seem that, I mean, of course, I haven't had a chance to read this Watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read Watchmaker. I'm just wondering if amending the Overt Act, we would be running into a constructive amendment claim. Constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor.
Mm-hmm.
One is the meaning of the word amendment in this circumstance. So if we were changing it to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored to those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. I don't think there's anything that compels that conclusion. In other words, I don't think this is a throw out the baby with the bathwater scenario.
I would argue that the amendment is actually not favorable to us. That amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I agree. It
elements.
doesn't work in the defense's favor to make it easier for the state to prove.
Let's throw it out.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean,
The state, y'all messed up.
even I'm reading Watchmaker right now,
It's a completely different case. I just glanced at it too.
and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the Overt Act. I think the safer thing to do is just to redact the indictment to remove those overt acts. I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, the 90, y'all haven't said it, but almost, I don't know, it was never mind. It was some kind of football field reference that I'm not going to be able to do right. So just never mind. The 1 yard line. And then, yes, y'all probably
I
said
thought
2
you were going
yard
to say
line.
risk introducing further error into this case.
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today, I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
Pay.
So, Your Honor, if I can respond to that, two points. One, it's important, I think, to be specific as to which act you're talking about.
Okay.
So with 183, there's no change in the nature of the crime. We're only talking about striking out those specific instances.
Right.
I can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely. With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Pay says she's trying to make 100.
With regard to, I had 2 points.
Okay.
One is, when you're talking about, forgive me if I get the number exactly wrong, but 170, I think it's 174, 175, 89, and 90.
Yes.
And so with those, specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first and inches.
Mhm.
However, because of the way you have instructed the jury
Mhm.
to handle the overt acts, if they find these and if there's a defect, those in public court simply strike them into consideration.
Unless they're the only acts they find.
In which case we would know that as well.
All right.
Because they're going to number them.
Understood. I'm just gonna redact them. Y'all will still have over 100 overt acts for them to evaluate.
But he said she don't want to get to the 1 yard line and mess up. She's trying to make 100 because 99 and a half just won't do.
All right, so I am redacting out to delete 174, 175, 189,
Yeah,
and 190.
not desperate, Doug. Hey, Floyd, see ya. So I'm assuming since he don't work there anymore, he's probably getting paid on a contract
I
basis
don't know why it won't let me.
from that other bucket
And
of
then
money.
on
Uh,
183, it will be the language that is now 183A, but it won't say A, it'll just say 183. And then the same with 187. Yes.
This already may be fixed, but with both of those, of course, redlining or removing the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think,
that's what I'm
I
doing.
think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right.
Hilton, what you got in your hand? What's in your hand? Some evidence she put in her purse?
I think
Oh.
I can't do the rest of it until Miss Percio comes back because she has the same document up, and for some reason it's not letting me
I'm telling y'all, the case, the
remove
jury
the highlights.
do not care about their body.
All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office.
He didn't want to work under love.
And Miss Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen.
Judge, that's on you though. The judge tried to make it seem like, hey, I wanted this, but she really not, in control of the ship. The captain's supposed to be in control. Well, yeah, I wanted us to leave the dock at 12 p.m. But the crew kind of not ready. I was waiting around on y'all, and they still got to eat lunch, and they haven't lifted the anchor. Well, hold on, you the captain or you not? Somebody say, Judge, get control of your courtroom, and Hilton, put the watch back. Get the watch out your purse and put it back on there in that box. I think the best way to avoid confusion, if the jury wants something, let them ask for it. If the jury want to see the jury, let them ask for it. If they want to see a video, they can ask for it. There was no reason she shouldn't have let them start deliberating right now. I mean, trust me, they're not going to be digging through this box when we got Thanksgiving on Thursday, they're ready to go home, be with their families, get on the flight, start cooking. They're not gonna be digging through 1,000 pieces of evidence. Oh. Right. Yeah, she can say that. I remember going on a cruise one time, and we stopped, and everybody got off, and they said the ship is going to leave at this time. Now, whether you back or not, it's totally up to you. But the captain letting you know this is what time the ship gonna leave. So not be here if you want to, you're gonna get left. And that's pretty much what the judge need to do. If y'all haven't went through it, I told y'all to go through it. I told y'all when to go through it. The jury here waiting, don't even worry about it. Leave it out. But she's trying to save face for the TV cameras. It's not my fault. I told them to do it. They didn't do it. Yeah, I'm like, Keys, just not guilty at this point. And tell her what? About her
All right,
county?
Ms. Percifield has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do, and then if so, we'll print it out and that'll be ready to go to the jury as well.
All right. So
At which time the last thing we will be waiting on is the evidence.
Right. She said that ship is sailed. Right. Hilton and them try to come in there with some new stuff. Just, hey, that ship is sailed. We passed that. We moved on from that. We passed that. Like, what they say is above me now. Look at Hilton. Well, Hilton thought she snapped last night, boy. She thought she snapped. She like, oh yeah, look at her. Look. That's how she was doing last night. Oh yeah. Yeah. Clock that T and catch it and all that. Oh man. This is funny. Oh. Right. I'm sure they back there talking about the state right now. Like, what we waiting on? Somebody said we can't clock it. We can't clock it because you got the damn watch. Excuse my language. Right, and then they quoting the case. They quoting a case called Watchmaker. We need a case called Watchfinder. We need the case called Watchfinder.
From getting this to the jury. Perfect.
Oh.
All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence, and so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room.
No, they're going to keep it all
the
right.
court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
You heard what the judge said. The DA's office needs to keep that. They kept it. They keeping it for sure.
I know, right?
Wait a minute. Hold on. Did he just say there's he don't want to make sure there's an allegation that it's stolen? You passed that. Y'all heard that?
Evidence that is not going out with the jury.
I know, right?
Oh, he said at least now it won't be an allegation that somebody stole it. We passed that. The allegation's been made. Where did watch at?
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure we send them. I think we don't get separate things. We just gotta make
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So whatever needs to get done, let's do it now.
We've been saying that in the chat. Haven't we been saying that? Whatever y'all got, give it to them. If not, too bad. You the captain, Paige. Start acting like it. So now we wasted 2 hours of the jury's time.
I don't know who they belong to. It's just extra. I think it's just folders. Yeah. There's literally, it's just folders.
And to y'all may say, to us, 2 hours may not seem like a long time, but that's a lot. I had the cases decided in 10 minutes. They could be on their way home. They can be packing for their flights so they can leave out of town for Thanksgiving. Start going home and cleaning up their own house that they're going to be hosting Thanksgiving.
Then y'all will have to wheel it over and we'll display it in the courtroom. No.
Mm-mm.
No, I mean, they might deliberate for a month and a half.
And why would you have a gun?
I'm going to be using this courtroom for
Right.
the other
Why would you leave a gun in there?
defendants on this indictment.
Right.
So no.
That don't even make sense. Who want to leave a gun in a courtroom?
These are separate entities. Investigator Dennis's stuff that was taken out.
Okay.
Jimmy Winfrey, plea that was taken out,
Okay.
and a transcript for Mr. Sledge.
All right.
So these are all different things that were either removed from evidence.
This is confusion.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Look how disorganized this look, though. Just look at it.
Your Honor, I've looked at the revised indictment that we just received, and it's acceptable to me.
Thank you.
Look at this. This is complete confusion. And we already know who the author of confusion is.
That may have been Mr. Sledge's pleas or something like that.
Look, they digging through boxes, contaminating evidence. Just now I see why the police department's so sloppy and the DA's office sloppy. They didn't got a grocery cart and just pushed all the evidence upstairs to a different court. What they say, left hand don't know what the right hand doing as always. Yeah. And I think, don't it supposed to be that way, Toker? You don't let your left hand know what the right hand doing. Oh man. I've never seen this in a courtroom in my life. Had more evidence in DNA in the OJ trial versus this nonsense. I'm telling y'all, they're making a bigger deal than they have to. I would be shocked if we get a jury note saying, hey, I want to see such and such video again. Now it could happen if they're, let's say it's 11-1 and they're trying to prove something to the one person that's not in agreement. Hey, you didn't see that video? And then they'll come and say, hey, we need to see that video again so we can show the juror such and such that all 11 of us are right. I mean, I can imagine a situation like that, but for the most part, no. Somebody said we need Glanville Dog in there to get some order in the court. Order in the court. Thank y'all for popping in and liking the video and to the new people that subscribe. Thank y'all.
Okay. Okay.
Wait, Keys, who you talking about, Keys?
All right, and I'm just going to put on, Ms. Taylor, I'm going to put on the record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right, so 1AS that I referenced before, I've realized that is the exhibit number from Mr. Sledge's plea, and it's not the exhibit number for this trial. The exhibit number for this trial is 444Y. They were just the same thing.
No, Pete. No, I never had the desire to be one.
Yeah.
But the 444Y would stay in that.
It's in evidence, but I don't think it would go out.
So that came in, that was back. What was the other number that you were concerned about? They're looking at
They're the same. No, that was it. It was 1AS, but that's not an exhibit to this trial. So it was just the way that exhibit was referenced in Sledge's agreement. So don't worry about that at all. Okay. Yeah. Okay.
I will say this with my I will say this, my law school, I call him my law school best friend. Like
All right. I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry in number 2. I am.
So he ready. You ready, Judge? You ready?
They're all right there in the middle, right there. Yeah.
That's all of them right there. That's everything. Oh, is that in here? Wait, the indictment is not there. The indictment is not there.
5 years.
The indictment.
We have to print it out.
Yeah. Yeah.
All those demonstratives that are right there go? Okay, thank you.
Yeah, what I was saying, my law school best friend, when I came out, I became a defense attorney. He became a prosecutor. And then when I started practicing personal injury, suing the insurance companies, guess where he went to go
Your
work?
Honor, this
He
is
went to go
just
work for the
purposes
insurance
of
company
the record.
as a
The state
defense
has
attorney.
reviewed the revised indictment, and it's going to be printed. I was just going to put for the record that the state, would object to the removal of the 133 counts, overt acts, that are 174, 75, 189, and 190. Thank you, Your Honor.
What you say, Pete?
She's waiting for that.
Shannon not going to walk
I don't know.
guilty or something for real.
Right here? Yes. You can use the lid, just don't give me that paper.
Oh, this is ready.
No lid? Oh, okay.
That deputy got somewhere to go. He moving fast.
What happened?
This one right here, he ready to go.
They're over there. They're over there. LT.
This is complete right. Look at this. And they really showing this on national TV. Probably more than national, because a lot of people here on YouTube are from out of the country. So they're like, wait, this is what y'all justice system look like? Somebody said Shannon's in too deep, but I wish him the best. He said he in too deep, too far in to turn around. This is shameful.
I have a few things, but. I just figured I kept all that together. I'm gonna try it like statements. Oh, good. Thank you, just in case we need it. Yeah, or wheel it back there, I don't know where you want it. I guess you can take it into the jury room in case they ever use it.
Right. When she first started off, she was kind of like, I'm taking control. Glanville ran it that way, but I'm not Glanville. I'm going to do this. I'm going to do that.
All right, while the jury is deliberating, Ms. Persfield's going to check to make sure she has a cell phone number for each of the attorneys, because obviously we have no idea when and or if they might want to ask a question or look at evidence. And so we all need to be on standby. We're all still in trial. And I need for people to be able to get here, in 5 minutes time.
5 minutes?
Ideally,
How they gonna do that?
if you have a special place you need to be, we can talk, but in short order. And obviously, the defendants will continue to come over each day that the jury is in deliberating, so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them
Oh,
tomorrow?
it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. I mean, not past 7 ever. Which I don't think they're going to want to anyway.
Not past 7 ever, but they left last night at 8 something. Make it make sense. Y'all, so we're gonna be in vertical watch mode. And she wants the lawyers to stick around.
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what the schedule, what's going on, very briefly.
Thank you.
No, don't put me in nobody group chat. Hey, y'all ever got the
No,
people?
Friday was already scheduled as a holiday date a long, long time ago. No.
Y'all get them group chat messages. Take me out this group.
Mm-hmm.
Oh man.
I'm gonna make sure that let me do this first and then I will. Yeah,
Oh my
exactly.
God,
Oh,
that's
for sure.
hilarious.
Absolutely. We're only using WhatsApp. Come on.
Right. You ain't gonna be texting me all day and night. No. But I think now you can mute the group. You can mute it and look at it when you want to. AB said it only take her 10 seconds. Right. I don't think I'm not foreseeing this going that long as they think it's gonna go. Because she's saying Thursday and Friday is out. Tomorrow, 9 to 3, unless they want to go longer, and then start back Monday 9 to 5, unless they want to go longer. Well, one thing about when juries deliberate, it don't bother us because there's nothing else for us to do at that point. All we got to do is just kind of stay close to the courthouse in case they have questions or they have a verdict. I have a group muted right now. What group you got muted? So I need to let them know you got them muted, Blue Skies. Who you got muted? I tell my family, they know, hey, if it's something important, do not put it in the group. You got to let me know, individually. I'll put it in the group. That group muted. I don't be paying attention to that group. I don't pay attention to that group. You put it, if you don't want me to see it, put it in the group. Tia gone. Somebody said, let's start the verdict clock on the missing watch. You know what, Tia? What did I do? What did I? All right, Blue Sky, I'm not going to tell on you. I'm not going to tell that you got the group muted. Fine. I'm not going to tell it to you. I'm not going to tell on her. I wish the best for Shannon and Yak and Ho. They can put this behind them. I wish Thug hung on, but he did what he thought was the best sitting in jail for over a year or two. Yes. Thank you for that comment. Yeah, look. Wait, hold on, what did he just say to Whitaker? Oh, y'all heard what he said? He said the mic in the courtroom is hot. The mic in the courtroom is hot. Y'all heard the deputy said that, so they watch what they said, watch what they say in front of us. Listen what he said.
I know, right? Okay, thank you. We didn't say anything, but glad we didn't say anything.
She said, we didn't say anything, but glad you told us. Boy, the deputies be snitching, boy. We didn't say anything, but glad you told us. He said they won't be home for Thanksgiving, but they'll be home for Christmas and New Year's. Why you say that? Oh, they have other charges they have to resolve? Gee.
All right, with that is everything. The jury has the case, and we are in recess until such time as we hear from the jury.
All right, y'all. So it's saying, so the jury's in the case around 2:30. I think we're a few minutes. We might be a few minutes behind. Peace. Y'all, so Doug trying to figure out what's going to happen with his client, because what happens is, or what could happen, they can come and say, hey, we have a question. Well, the judge cannot just read the question and give an answer. You got to have everybody there. So the lawyers need to come back. The defendants, prosecutors, defense attorneys, everybody needs to come back, and we're going to read these questions together. Y'all anybody got any final words they want to say before we get out of here? I'm gonna drop the link. If not, I'm gonna be on standby, like the judge say. I'm gonna be close. So if I hear that there's a verdict, I'm gonna throw a tie on so fast. I'm gonna throw this tie on and run to this camera. So I'm gonna keep the camera charged. Make sure y'all notifications are turned on. Y'all know how to do that, right? So y'all don't miss nothing. Somebody, Bruce, say, see you in 3 hours. Yep, the jury has the case. So shout out to the jury. They finally have a case after all this time. the jury will have the last word. I did find it interesting. Hilton pointed out that Max didn't cover the gun that his client was accused of having. Remember, it was a gun that was found in the middle of the street after a police chase. And they said that Max really didn't address that. Maybe his, position is it was a gun in the street. That gun was not found on his client. But I'm not sure if the gun he found was Taisha's gun, his girlfriend's gun. Then, logic would have it. If you're fleeing from officers and the gun's in the street, and then that gun happens to belong to your girlfriend at the time, then you were a felon in possession of a firearm at that time. But that, I don't know. But Max may say it's in the street. You didn't catch him with the gun on his person. Hopefully the jury, yeah. But all right, y'all. I guess we're gonna just stand in recess. We're gonna stand in recess, and we'll be back. Thank y'all for popping in, though. I definitely appreciate it. Any final questions before we go? Were we thinking not guilty, hung jury? Well, hung jury won't happen today, right? Because if they can't agree, the judge will say, okay, keep working. You're going to keep working later today. If not, tomorrow, keep working. We still can't agree tomorrow. Okay, we're going to come back on Monday. Keep working. So we're not going to get a hung jury either today. You only can get two things, guilty or not guilty. And I don't really see them finding them guilty today or any day. Not on the main charges for sure. The one with the gun in the road, that's kind of questionable. Would they make a compromise, or would they say, that's not enough, not guilty on all counts? If y'all have any suggestions, let me know. Put it in the comments or email. Let me know if y'all have any trials that's coming up and y'all think that, it's good, not guilty. Oh yeah, 7 streams, thank you. Not guilty per juror 56. Like Walmart says, attention, your party is waiting for you as customer service this year. Do you know we're covering next day? Max was like Shaggy, it wasn't him. Okay. All right, y'all. Thank y'all a lot. I'm gonna stick around. I'll be in the area. So if y'all hear anything, let me know. And we'll just jump back on and we'll see what the verdict's gonna be. If not, there's no sense in wasting time. Might as well get some stuff done. The sheriff yeah. I wonder when that trial starts. That would be a good one. And that's why the judge said she don't want no guns just left around in her courtroom, just hanging out. Anybody can grab that gun. You don't know what they may try to do. Okay. Thank you, KB. Thank you, Paris, and also for being a member. All right, y'all. Let me go. Have a blessed and happy Thanksgiving. Yeah, happy Thanksgiving to y'all as well. Because obviously, if the jury doesn't make a decision today, they don't make a decision tomorrow. It's not like the court's going to have cameras in the courtroom tomorrow. The jury would just be in the back. So we may not see each other until after Thanksgiving. Who knows? Hopefully we get a verdict today and be done with it. Oh, thank you, Paris. All right, y'all. Before I go, let me give my legal disclaimer. No legal advice intended. Pete said, I'm not your lawyer. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. Thank y'all so much. Definitely appreciate all of y'all. Say no, don't go. Happy Thanksgiving. It had music in it, so YouTube is, I don't know if we're going to crop that out and figure all that out. If we can, we might get that put back up. So I'll be working on that. Thank you again, Pete, and thank you, dear woke Christian. All right, y'all. Y'all have a good one, and I'll see y'all on the next one. Let's go.